On October 4th, 2024, Judge Mogan of the Burnett County Circuit Court in Wisconsin issued a permanent injunction against property owner Carl Alexiams following a civil dispute with his neighbor, Rick Brimacombe. The core basis for the lawsuit rested on the property's land use classification. Because the home is situated in a residential neighborhood rather than a commercially zoned district, operating a high-turnover vacation lodge constituted an unpermitted commercial business that created a private nuisance, infringing on neighboring owners' peaceful use and enjoyment of their land. Consequently, the court order explicitly prohibited Mr. Elysiums from operating a short-term vacation rental at his residential property unless and until he secured a mandatory state lodging license from the Department of Agriculture, Trade, and Consumer Protection, known as DATCP, along with a Burnett County rental permit. Despite the binding judicial order, Mr. Elysiums continued offering his property on hosting platforms throughout the summer of 2025. In response, Mr. Brimacombe filed a motion for civil contempt, alleging deliberate and repeated violations of the injunction. Additionally, Mr. Elysiums filed a motion to stay the court's order pending appeal, seeking to halt enforcement while the appellate court reviewed the ruling. However, the court noted that an appeal does not trigger an automatic stay. Representing himself pro se, Mr. Elysiums attempted to rely on Wisconsin statute section 66.1014 2D2, specifically arguing that property owners operating a short-term rental for 10 nights or fewer per year are exempt from obtaining state licenses or local county permits. However, under established principles of judicial supremacy, a general statutory exemption does not overcome or supersede a pre-existing court injunction. Mr. Brimacombe was represented by attorney Christopher Anderson. The first witness called to the stand by the plaintiff was Mr. Alexiams himself as an adverse witness. After repeatedly failing to recall the specific rental dates questioned by Mr. Anderson, he was excused from the witness stand. The next witness for the plaintiff was Mr. Bennett, a vacationer who had rented Mr. Elysium's property during the summer.
Thank you, Your Honor. Mr. Bennett, you began to talk about a document that you may have been looking at. In the upper left-hand corner, is there a VRBO emblem?
Yes.
Okay, and then does it say get the app, USD, and some other words?
Yes.
Okay, and below that, does it say pricing?
Yes.
Okay, and at the bottom of the page, there's a heading that says booking made easy. Is that on yours?
Yes.
Okay. And in the middle of the page, it says price details, and then it goes through a price and has payments, payment one paid, and it has a number there. Do you see that?
Yes.
Is that what you were looking at to refresh your memory?
Yes, it is.
Okay. Your Honor, he has Exhibit 3 in front of him. I would submit to the court.
All right, any objection?
No.
Received.
Mr. Bennett, in looking at Exhibit 3, it says $6,950.48. Is that what you paid?
Yes, it is.
Okay, and that was to stay at the property for 8 days and 7 nights. Is that accurate?
Yes.
And when you rented this property, when you went through VRBO, that was, or you understood it to be $809.29 per night for 7 nights. Is that what your understanding was when you rented it?
Yes.
Mr. Bennett, I believe you also have a document in front of you that we've labeled here as Exhibit 5. The first page, I believe I'm sorry, 4, thank you. At the top of the first page, it says booking confirmation. Do you have that?
Yes, I do.
Okay, and then it appears to be a letter. It says, Dear James. Do you see that?
Yes.
Okay. And then the second page, just to make sure it's the same document, the second page at the top says rental agreement. Do you see that?
Yes.
Okay. And this entire exhibit consists of 5 pages. Is that accurate?
Yes.
Okay. And I would submit that he has Exhibit 4 in front of him at this point.
All right, are you requesting the court receive it?
I mean, well,
I'm sorry,
I'll lay some foundation maybe, but
Yeah,
Exhibit
sorry,
3, I would ask.
I was trying to look at something related to this, and I missed your question. He has it in front of him. Thank you.
Okay. I would offer Exhibit 3 at this time, though.
Mr. Elysiums, any objection to Exhibit 3?
No.
It is received.
So you're not offering 4?
Not yet. He has to lay foundation. I jumped forward a bit. Continue, Mr. Anderson.
Thank you, Your Honor. Mr. Bennett, when did you book, or how far in advance did you book your reservation at this property on VRBO?
If memory serves, it would have been about 7 to 8 months.
Okay. And then looking at Exhibit 4, it says booking confirmation and then rental agreement. Do you know how you received this document?
Yes, we received a link to it in the Verbo messaging app, the VRBO messaging app.
Okay, and do you remember when you received this document?
Yes, we received it the night before our vacation started, about 5 or 6 p.m.
Okay, and that would have been July 18 of 2025.
Correct.
Okay, and when you received it, well, first of all, when you received it, did you look at it? Did you read it? What did you do with it?
Yes, I looked it over and then signed it.
Okay. And was it requested that you send it back somewhere?
Yes, it was. Carl Alsiams requested that we sign it and send him a confirmation.
Okay. And when you received it, what were you in the middle of doing?
We were preparing for a week-long vacation, so we were packing our bags. I was loading the vehicles, the truck, the boat. My 5 children had dropped off their luggage and their coolers, which I usually load up in my vehicles because I have a lot more space. So I was in the process of preparing for our vacation.
Okay. At some point in time later that day, did you look at this booking confirmation rental agreement again?
I did after my wife brought it to my attention that he had showed that part of the stay was complimentary and that we actually only paid for 2 days and that the rest was complimentary. She brought that to my attention and then I looked it over again.
Okay. Did that give you any concern?
Yes, actually a great deal. We were concerned that he may have been trying to leave himself an out to force us to leave early. Our thought was that maybe he had double booked it and was giving himself a reason to evict us early.
Okay. Ultimately, you were able to stay for the entire 7 nights, 8 days. Is that true?
Yes.
Yeah. Would you have paid nearly $7,000 for a 2-night rental?
No.
Okay. Your understanding was that you paid for 7 nights, $7,000 almost for 7 nights and 8 days. Is that correct?
That is correct.
Your Honor, we'll offer Exhibit 4.
Mr. Olsians,
No objection.
it is received.
No further questions of this witness, Your Honor.
Mr. Olsians, questions?
Just a couple.
Okay, you may proceed.
So can I call you Jim? Is that okay?
Yes, that's fine.
So Jim, you paid VRBO directly, correct?
Correct.
And looking at the pricing, you paid a service fee, which, by the way, do you know what a service fee is on Exhibit 3?
I guess I assumed that it was a fee paid to VRBO.
Okay. So that's not money that went to me, correct?
Objection.
I don't know
That went to
Objection.
When there's an objection to all the witnesses who will be testifying, somebody says either Mr. Olsians or Mr. Anderson says objection, you need to stop talking so that I have an opportunity to rule on that objection. So the answer or the question was, if he knew what that service fee was and that it did not go to Mr. Olsians or something to that effect. I could read word for word if I need to, but that is an effect of what was asked. You objected.
Foundation and speculation is the objection.
Any response?
It's not speculation. He's the one that made the payment. He knows what he's paying for.
Well, that's not a legal argument. It is sustained. So you have to build a foundation for that information to come in, or the relevance.
Well, the relevance is that
I'm not having you argue that to me. I'm just saying that in your questioning to Mr. Bennett.
okay. So Jim, is it your understanding that that money was to go to me or to VRBO? The service
Are you
fee?
specifically asking about the service fee?
Yes. Is it your understanding that was to go to me or VRBO?
Objection relevance, Your Honor.
Sustained.
The tax, the next item is tax. Was your understanding that was to go to me or to the local governing authority?
Same objection, Your Honor.
Sustained.
You made in your testimony, you said 8 days and 7 nights. Isn't it 7 days and 7 nights? Not 8 days and 7 nights, correct?
I'm sorry, could you repeat the question?
You testified that you stayed 8 days and 7 nights. Isn't it correct that you stayed 7 days and 7 nights?
I think that would depend if we count the day that we packed up and left that morning. If we count that as a day, then we were there for 8 days. We left the premises by 11 o'clock that day, but we were there at least part of that day.
Right, but my question goes to the 24-hour unit of a day. For example, if you were to have a 2-day rental, if you checked in the first day and checked out the second day, that would technically be a 24-hour period, but crossed 2 physical days, correct?
Your Honor, I'll object. This is argumentative. It really is an argument that he's trying to make, and it's not a fact. He was there from July 19th through July 26th. How we count the days is an argument, not a fact.
Okay.
Sustained.
So Jim, you checked in before 4 p.m. on July 19th, correct?
No, we checked in at 4 p.m.
Okay, on July 19th.
Correct, on July 19th.
Okay, and when did you leave the property? What time and day?
He's already answered. July 26th, 11 a.m.
Okay.
Sorry, I wasn't going to wait for an objection to ask the answer.
Did you pay a damage deposit?
Objection relevance.
Sustained.
And did you rent the pontoon boat?
No,
And did you cause any kind of disturbance at the property?
Objection relevance.
Sustained.
Were the police called to the property at all during your stay?
Objection relevance.
Sustained.
No further questions.
Redirect.
None.
During cross-examination, Mr. Elysiums asked Mr. Bennett whether the police were called or if any disturbances occurred during their stay. Mr. Elysiums likely sought to establish that the stay was entirely peaceful and without incident. Under Wisconsin statute, section 947.01, engaging in unreasonably loud or improper behavior that disturbs the peace of a neighborhood is legally prohibited and can warrant law enforcement intervention. Mr. Anderson promptly raised a relevance objection, emphasizing that the central issue before the court was the host's unlawful rental agreement and improper booking terms, not guest misconduct or neighborhood disturbances. During direct examination, Mr. Anderson focused on establishing the true meeting of the minds regarding the rental agreement. Mr. Bennett confirmed under oath that he paid nearly $7,000 for a 7-night stay and explicitly testified that he would not have paid that total for a 2-night rental. Through this line of questioning, Mr. Anderson's legal strategy exposed Mr. Elysium's attempt to manipulate the contract. Under the legal doctrine of substance over form, courts look at the economic reality of a transaction rather than artificial labels. By proving that the payment was mathematically calculated for the entire week, Mr. Anderson demonstrated that the complimentary designation was an artificial pretext used by the host to mask the actual length of the commercial rental. After Mr. Bennett's testimony, Ms. Tate's testimony relies on staying in the property for the span of 3 days, with a total of 12 people. After that, Judge Mogan gave the opportunity to Mr. Elysiums to give his testimony.
Mr. Elysiums, this is your time and your time to give me all the information that you wish to give me, all the testimony you wish to give me as it relates to Mr. Brimacone and Mr. Anderson's motion. You are under oath. You may begin.
I have a quick question. My exhibit 1 is the same as their exhibit 4. So I don't know if I need to.
You do not need to use that. You can go off of exhibit 4.
Okay. Can I bring exhibit 4 with me to the box?
Yes.
Well, very briefly, Your Honor, the order that that you wrote does not say that requires a license from the county.
Well, let me read what my order says.
Okay.
Words are words, and I used words. My order said, the court finds that the plaintiffs have met the burden of proof and that there is no genuine issue as to a material fact. The facts asserted by plaintiffs are not refuted by fact or evidence and are so clear and convincing to the trier of fact that there is nothing left to establish. As such, the court hereby issues a permanent injunction, that's in all caps and bold, until such time Mr. and Mrs. Olsiums comply with and receive the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. That's what the court said.
Well, my understanding of the order in conjunction with the county ordinance says that 10 days that I can rent the property for 10 days or less without any kind of county permission, license, anything. That's what the county ordinance says, and I believe that's what the right to rent state law makes a reference to that as well. So under that understanding, again, your order has to be in conjunction with the ordinance. So,
No, it doesn't.
well, if the ordinance says something, you can't change the law.
That can be your argument. I will tell you what I can
Okay.
do as a judge when I'm going to make my decision. I will stop.
Right. Well, the ordinance says that I can rent for 10 days and not have to get any licenses, permission. nothing.
Your Honor,
So,
you've made the comment already about argument. I was going to do that earlier, and there hasn't been any actual testimony so far. This needs to be factual. The argument can be made from there or in
I'm just laying a
writing.
foundation for my state of mind.
All right. Well, I don't need a foundation for your state of mind. I understand you've heard my order, the words that were in the order. And I heard that you believe that the ordinance states you can rent for 10 nights or less without needing to get the permit. Okay.
Right. So I went ahead and rented my property for 10 days for this past summer, 2025.
All right. So I'm hearing right now, I just have to make sure you are admitting and stating on the record, you rented it for 10 days.
Correct.
All right.
And with, I'm looking at Exhibit 4. What I did is I said that 2 days of the 7 were paid and the other 5 were complimentary to kind of save 5 of the 10 days. So of this, for Mr. Bennett, I'm counting 2 of the 10 for that purpose.
Okay. Got it.
And that's what's shown here on the rental agreement.
All right. So then go forward and continue to go down, tell me the days that you rented, to whom you rented it to, and we'll go from there.
I don't remember. I just specifically remember it was 10 days when you include the 2 days, the Memorial Day weekend, the Labor Day weekend. So that would be 2, 2, and Mr. Bennett is 2, that would be 6. And I think there was another rental in there. I just remember that I wanted to keep the limit at 10.
All right. And so with the Memorial Day rental, with the Labor Day rental, with Mr. Bennett, it was, you rented it per your contract or how you had written the contract, 2 days for each. So a
Right.
total of 6. So where's the other 4?
Well, we got the Labor Day, right? Did we
I already
include
did
that?
2, 2, 2. So that's 6. So there's another 4.
Let's see, that would,
Because we have the May, we have the September, and we have the July with Mr. Bennett. So
I guess what I'm saying, I kept within the 10 days. I don't remember exactly the 10 days specifically, but that was my goal or my intention is just to stay within that 10-day limit.
All right, what else do you want me to know?
I think that's it. It's pretty basic. That's, I admit to the renting. My understanding though, it's 10 days or less. That's what the county ordinance is. That's what the state law says in the right to rental.
Okay, and so nothing else you want me to know? And what about the money issue? You wanted to argue about the money issue. Tell me about that, or not argue, tell me about that in your words, because you were saying you were trying to have other witnesses tell me about money.
Well, just that he's trying to argue if he tries to argue a sanction that I was paid $5,000, that all didn't come to me. There were tons of VRBO fees and taxes and things like that.
Okay,
That's just the point I was making there.
understood. So you didn't receive all the fees. Some of the fees went to VRBO and some went to taxes.
Right.
Excellent. Okay. Anything else?
That's it.
Mr. Anderson?
Mr. Olson, to be clear then, you did not receive permission from Burnett County to rent your property in Burnett County, true?
I never asked them for permission.
Fair enough. Then you never received a license from the state to rent your property in Burnett County, true?
No, because my understanding is that I didn't need a license for 10 days or less.
Okay, so no, you didn't.
No.
No further questions.
Mr. Olesims admitted on the record that he obtained no permissions, permits, or authorization to rent out his property. Under Wisconsin Statute Section 785.011B, the intentional disobedience, resistance, or obstruction of a lawful court order constitutes contempt. When a court issues an explicit injunction directing a specific named party to avoid particular conduct, that judicial mandate carries the full weight of the law, and any deliberate failure to comply exposes the party to statutory sanctions. Here, Mr. Olesims directly admitted on the record during his testimony that he rented out the property for a total of 10 days during the summer of 2025. The property owner attempted to lay a foundation regarding his state of mind, testifying that he believed local county ordinances and state right-to-rent laws permitted unpermitted rental operations if kept to 10 days or less per year. But as the court clarified on the record, under Wisconsin's collateral bar rule, as State versus Buzek, an explicit judicial injunction issued against a specific party takes precedence over general municipal statutes. This renders his subjective state of mind defense legally irrelevant and establishes a clear violation of the court's order.
Argument.
Your Honor, so a couple of things. I don't think well, first of all, Mr. Olsims has admitted to renting the property in Burnett County, in my opinion, in violation of the court order. We heard testimony from Debbie Tate that they brought multiple trailers, multiple ATVs, multiple vehicles. They had 12 people there one night, 10 people there another night. We heard testimony from Mr. Bennett that there were double-digit people on the property. There were multiple vehicles on the property again. This is sort of that nuisance. It's not sort of. This is part of the nuisance that has been part of the problem. There's been more than that, but that's been part of the problem and part of the issue of how many people are renting the property and staying there when this is not a commercial property. We've also heard testimony from Ms. Tate that she was there for 2 nights, 3 days. We heard testimony actually from Mr. Olsims that, well, I'm sorry, not from Mr. Olsims. We have exhibit 1 that shows that the group that was there in August 28th through September 1st was there for 4 nights. It says $995 times 4 nights. We have testimony from Mr. Bennett that they were there for 7 nights and 8 days. And they booked their vacation, I think he said 7 or 8 months prior to the vacation actually occurring. And then we have a rental agreement sent to Mr. Bennett at 5 p.m. the day before they are supposed to go to the property owned by Mr. Olsims for their 8-day family vacation. And obviously they signed it and moved on. And then they looked at it later and saw that there was this clause in there about complimentary days. That is a sneaky way of trying to get under the 10 days, which I don't think applies anyway in this case. But even if it does, Your Honor, the point of it is they were at the property for 7 nights and 8 days. The people from August 28th to September 1st were there for 5 days and 4 nights. We're already at 11 nights between those two. And then we have Debbie Tate, who was there for 2 nights and 3 days. Now we're at 13 nights and more days. And then not even to mention the other 2 groups that were renting, one from August 8th through August 15th, which again is another 8 days and 7 nights. And the last group being June 6th through the 8th. That was the one with the ambulance. There's less information about that, frankly, but there was extenuating circumstances there. But point being, Your Honor, there were renters there in far greater numbers than 10 nights. And again, I don't think that applies, but since Mr. Alsium's arguing it, I feel like I should respond to that because we are at 13 nights just for the 3 groups that have been proven here today in court without even considering the additional 2 groups. So any way you slice it, Your Honor, whether it's by what I consider the letter of the law in terms of he's not supposed to rent, period, without a license or permission from Burnett County. But even if we do have if that is the law, which I don't believe it is, he's still in violation of it. So frankly, a lot of the argument from Mr. Alsium's doesn't matter because he's in violation either way. If you want me to address sanctions, I can do that. I can do that later. I would ask for attorney's fees, Your Honor. And I didn't know how long today was going to go, so I'd ask for a little bit of time to submit that. So I can't do that today because I didn't know how long it was going to be.
All right. So yes, argue sanctions, and then he will have the opportunity to refute all that you've argued.
All right. Your Honor, I think sanctions are appropriate here. He's already been found in contempt of court for this very same action in the past. The court sanctioned him then. I think the court should sanction similarly. I think Mr. Alsium is right. He predicted that well because I think I did it last time. But the fees that were paid, I can do the math, but there's the $3,980 that was paid for the 4 nights in September. And then Mr. Alsium talks about service fees and tax. Well, that's fine, but the cleaning fee went to Mr. Alsium's, and so did the $3,980 for that one. We can look at the one for Ms. Tate. She paid $1,990. Then she has host fees, which again would be to Mr. Alsium's service fee and tax. We can take that off. Those numbers again are fairly clear. So that's $2,380. Your Honor, we also have Mr. Bennett, and his was $5,665, which was the per night of $809.29 times 7 nights. That's on Exhibit 3. There's a cleaning fee that went to Mr. Alsium's service fee and tax. We can take those off, and that's fine. But I think that the profits and the money that was received by Mr. Alsium's are ill-gotten gains in a case like this, and those should be forfeited by him as a sanction. And then I defer to the court on additional sanctions. There was in the prior contempt order, Your Honor, there were purge conditions. Obviously, those purge conditions did not happen, and now we're here on round 2. And I don't normally expect to see round 2s on things like this, but here we are. And that's why I'm asking for sanctions as they are and attorney's fees. But again, I'd like give me a week or 2 to get that to the court.
Right. And so your argument is you are arguing for sanctions. Your argument is, if I'm hearing correctly, that you are making an argument and a statement that purge conditions were ordered by the court to Mr. Alsium's, and pursuant to the court's order, Mr. Alsium's did not comply with the purge conditions. So that's one of the arguments. The second argument is you're arguing for attorney's fees to have to come to court for today and all of the related expenses to today's hearing. Plus, you are arguing to the court that a sanction for Mr. Alsium's should be forfeiting all of the funds that he did receive and profit from the rentals that you had proof of.
That is a good summary.
Excellent. Thank you.
Mr. Anderson requests that the court order the complete forfeiture and disgorgement of all funds and profits Mr. Alessium's derived from his unauthorized rental. Under established Wisconsin statute 785.03(1)(a), remedial civil contempt mandates the inclusion of purge conditions, specific court-ordered compliance terms that afford the contender a clear opportunity to purge the contempt finding. As established in VJH versus CAB, where a contender fails or refuses to satisfy these purge conditions, Wisconsin law dictates that the non-compliance is deemed a willful continuing contempt, depriving the party of the purge privilege and executing the underlying penalties. In this case, Mr. Alessium's must not only be held accountable for failing to satisfy his previous purge conditions, but Mr. Anderson also demands that the court impose additional remedial and punitive sanctions. Under Wisconsin statutes 785.04, the court is explicitly empowered to impose severe statutory sanctions to terminate continuing contempt, including compensatory damages and profit disgorgement, daily forfeitures up to $2,000, coercive imprisonment up to 6 months, and punitive fines up to $5,000 or jail time up to 1 year to punish past defiance and vindicate judicial authority. Since witnesses such as Ms. Tate and Mr. Bennett provided concrete testimony and proof confirming they occupied and rented the property over multiple days, Mr. Anderson submits that Mr. Alessium's must be held fully accountable for his actions. He urges the court to enter a decisive order reflecting the full severity of the defendant's intentional noncompliance.
But in our other cases, it's my understanding and my interpretation of how these cases went. Would you say that you did have all of the documentation in the other hearings?
I actually didn't. I think Mr. Anderson is one that had all the documentation.
Not in the contempt hearing. Let's go to the other hearings.
Yeah, even the other hearings, it was Mr. Anderson that had all the documents.
Oh, so Mr. Anderson is better at keeping your records than you are?
For the most part, yeah. Because he's trying to prove rentals.
Oh, good job for keeping his business records, Mr. Anderson. Okay. And so then how do you pay your taxes, Mr. Alessium's? Because you need to keep business records. You need to know how much money is coming in, and you need to be able to report that to the state as well as the state of Wisconsin, as well as to the federal government.
Well, there's a federal law called the Augusta law, which came from homeowners that were renting their properties for the Masters, and they were renting them just for the tournament. And out of that came a federal law that says if you rent your property for 14 days or less, you don't have to declare the income.
Okay, all right.
It's called the Augusta law.
And so does that include all of your rentals or just your rentals in Wisconsin and then separately from
Per property. Yeah.
Okay.
So it's just kind of well, I know I have to stay under the 10. I don't have to do meticulous record keeping because it's under the 14 for taxes. So I just know it's 10 days or less. So it's kind of an informal, lackadaisical. I think the reasoning there is the difference between a serious business and just kind of informally renting your property, which is what the people did at the Masters. They're just getting some side income.
All right. Well, then I have to talk to my accountant.
It's actually a great law. And when you think about it, it's kind of you don't get to write everything off though. You get to not declare the income, but then you don't get the write-offs.
Okay.
So it's kind of the line between a serious renting business and, it's your property that you live in that you're just occasionally renting.
And what year did that happen?
Probably 30 years ago.
30. Why?
It's been around a long time.
I was in the rental business, not before I was a judge. And I did short-term rentals and things like that. My accountant never told me that. I'm going to go back and get my money back.
Did you do more than 14 days?
No, I did not. I stayed within the 10-night limit.
Here in Burnett County?
Yep.
Yeah, well, it's a nice law, actually. Again, it's called the Augusta law, 14-day.
I'm going to look at that, and I had other property too in other places, but my accountant is going to hear from me for sure.
So just in general, for the last couple of years until this whole thing is adjudicated, I've moved it from a serious rental business to lackadaisical, 10 days or less.
You're there renting some, but giving 3 days.
Right. Just to kind of like say somebody wants to stay 7 days and I'll try to stay within that 10-day. Well, here's some free days kind of thing, which I did for Mr. Bennett.
All right. Okay. All right, 3 days.
Mr. Oleksiums referred to a federal tax exemption known as the Augusta Law, codified as the Augusta Rule under Internal Revenue Code 280 AG. This provision allows homeowners to rent out only their primary personal residence for 14 days or fewer per calendar year without reporting the rental revenue as taxable income. However, Judge Mogan rejected this defense, emphasizing that federal tax exclusions do not exempt short-term rental operators from state and local tax obligations. According to Wisconsin Statute 77.52 and the Burnett County Local Room Tax in Wisconsin Statute 66.0615, the state maintains legitimate legal authority to monitor and regulate commercial revenue generated within its jurisdiction. Furthermore, while the Augusta Rule excludes qualifying revenue from federal gross income, it does not relieve the taxpayer of the legal requirement to maintain contemporaneous proof, demonstrating that total occupancy never exceeded the 14-day threshold. In this case, Judge Mogan reinforced that Mr. Oleksiums was legally mandated to retain and produce complete documentation for all rental stays and income derived from the property. And since this was not Mr. Oleksiums' primary personal residence, the Augusta Rule did not qualify for it.
And the point is, you know, the usage and flow on that, it's continuous flow. So even if, for example, if I have a party at my house and there's 20 people there for a weekend, that's not going to overrun the septic system. You have to have week after week of 30 people, you know, that's just not happening here.
Okay.
And so they're trying to argue smelly septic because there's more than, you know, again, just the desperation to try to, you know, climb in
the nuisances.
Right. But again, that was refuted because there was no inspection done. There was no professional that came out and said, yeah, it's malfunctioning because there were 14 people here that weekend. I mean, it takes week after week, month after month of over.
Right.
So again, so I think why a stay would be appropriate is that, you know, it's not, you know, just the nuisance part, which again, if that goes, you know, everything pretty much falls apart. If, you know, my claims, again, there was general disputed material fact. They basically got up and just with an affidavit said, I'm claiming this. And I got my affidavit in the same day of the hearing when we had that. So we have a disputed fact there. And all my claims were dismissed because
Okay.
so again, there's a lot of things going on. I think
What
that
is your legal basis? Do you have any case law? Do you have statutory law? Do you have something for me to hear or to understand? But what is your legal basis for requesting a stay?
legal basis is that
That means case law, that means statutory law. What is that basis?
well, I think well, statutory, as I mentioned, nuisance. Can this be a nuisance? This is a primary fundamental right of any property owner in Wisconsin. I've suffered, lost rental income for the last couple of years because of this. I certainly this is a major harm to me by.
Right. Yeah. Okay,
So,
I understand that.
so until I just think it makes sense that, structurally in case, with the law that, this isn't a garden variety, claim damages. There's a lot of legal, merits here that I think need to be determined statewide. And it makes sense just to put everything on hold until the appeals court rules.
Okay. So I understand that now. Now, with regards to the court's October 4th, 2024 order, I have your understanding of that order. You filed a motion to stay. The court did not hear your motion to stay, and I could have ruled on it at that very moment. I did not.
I'm sorry, 2025, you mean? Or
25,
Yeah.
October 4th, 2025, sorry. And in that order,
It's actually 24.
it is 24. It is 24. See, I was correct. October 4th, 2024, right?
There's another one that looks like it's September 5th of 2025. That was, I believe, the contempt part, but the original one is the October of 24.
Oh, yes. Okay. So thank you. This has been a long process. Thank you. Because that the important thing here and what the court has to do is take it by stages, because the court first ordered October 4th, 2024. And I read to you what the order was from the court that you must comply with. And I'll state again, the court hereby issues permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit, and continues to do so annually as required until such a time that the above depicted nuisances can be abated. That's the October 4th, 2024. Then the court had another order that the court entered on August 28th, 2025. From August 28th, 2025, the court had certain orders and found that you had certain compensatory and punitive damages for nuisance, for civil trespass, and for property. The court also found you in contempt of the court's October 4th, 2024, and had certain sanctions that were applicable at that date and time, and gave you purge. Do you understand what purge is? Gave you the ability to purge that, and to, as long as you complied with certain things, the jail, it says the things may be purged following full compliance of the October 4th, 2024 order, or 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. All right, so that was the court's August 28th of 2025 decision. And so with regards to the August decision, Mr. Olsiums, did you comply with that order?
I guess I don't,
Did you comply with that order with paying the court fine of $2,500 for each violation?
I didn't pay the fine, no.
You didn't pay the fine?
No.
Because I think if I calculate it correctly, I think the fine would have been due and owing October 26, 2025. So by October 26, 2025, you did not pay that court ordered sanction of the $2,500 for each of the violations?
I guess I didn't see that in the order.
But you did receive a copy of the order, correct?
Yes,
And you are an e-filer too, correct?
yes,
And so you did receive that order from the court, which does have that sanction, as well as it says court fine $2,500 for each violation, totaling $5,000, a 45-day jail sentence for each violation to be served consecutively for 90 days of jail. And it says that the jail sentence may be purged, and that means you won't have to sit the jail if you do these following things: full compliance with the October 4, 2024 court injunctive order, and full payment of the court sanctions, fines, and fees within 60 days. I get your argument as to you believe that you're in full compliance. You believe you complied with my order, but so you didn't pay those fines and fees by October 7th within 60 days from the court's order.
I don't think I even have that money to pay.
Oh, so, okay, but you got the order and you understood the court's order as well as the purge, correct?
Yes,
Okay.
Mr. Olesiams asserted that he lacks the financial means to pay the $5,000 court-ordered sanction. Under constitutional principles established in Bearden v. Georgia, when an individual fails to pay court-ordered fines or sanctions, the court must evaluate whether the non-payment stems from a willful refusal or a genuine financial inability to pay before enforcing further penalties. In response, Judge Mogan pressed Mr. Olesiams to explain his position and clarify why he failed to comply with the directives set during the previous hearing. When Mr. Olesiams contended that operating his short-term rental did not constitute a private nuisance, the judge asked him to cite any specific law that explicitly authorized him to rent his property under those circumstances. Finally, Mr. Olesiams reinforced his position on the alleged nuisance by arguing that claims were unproven due to a lack of professional inspections, asserting that property ownership gives him a fundamental right to use his land.
All right. So with regards to the motion to stay, there are things that the court has to follow. There are, and State v. Guddenschwager, 191 Wisconsin 2nd, and it's GUDENSCHWAGER, 1995. It says the court must look at 4 specific things. 1, the likelihood of success on the merit, irreparable harm to the other parties, and the public interest. All right, and I've heard the arguments of the parties, and I understand, Mr. Olsiams, you believe that this is going to create new law and precedent, and the Court of Appeals will make everything right and will define nuisance and will overturn this court's decision and the orders that I have, not just one, but two. I have two orders in this case, two separate orders in this case. Court here, I don't find that you have shown that or demonstrated a strong probability on appeal that it will be successful. The court thoroughly went over what nuisance was. The court thoroughly went over the violations that were occurring while you were renting your property out to other people. Very, very clearly in my first decision, because my first decision, it's 26 pages long. Granted, it's not all 26 pages. It's 15 pages of the court analyzing the law, interpreting the law, and analyzing the facts of the case, and then putting it on a decision in order. The other pages from page 16 to 26, those 10 pages, they were here to help you out. A guide to renting out your property for overnight stays. Protect yourself by knowing Wisconsin's law for short-term rentals. I gave you that pamphlet, so it would explain the law, explain what you need to do. So that was there. The second thing was the Department of Agriculture, Trade and Consumer Protection, the tourist rooming houses, and what you must do to follow that law for the DATCP. Then the court also provided you with the permit application for the tourist rooming house. So you could have that along with another brochure, the Wisconsin Short-Term Rentals Law. And it has little arrows and things and little boxes, and it makes it really easy to follow to make sure that what you need to do to comply with that law. The court then also provided the short-term rental license application for Burnett County, clearly gave it to you, showed what you needed to do, had it right there. And I also provided the Burnett County licensing requirements right there, so you could have them right there with the additional provisions. And then I, beyond that, provided Burnett County Ordinance Section 30-455 short-term rental, which clearly goes over what a short-term rental is. And I went beyond that because there's issues and arguments with parking. I put in Burnett County Ordinance Section 30-480 parking as it relates to off-street parking. And here it would be with short-term rentals. Very clearly laid it out because you were very clearly violating the law. That was well proven, directly proven. I don't think it could have been proven any more clear to the court that you were violating Wisconsin state law and Burnett County ordinance. And the court did state that. And then the court did, that's why I entered the injunction with those requirements that you, again, I will read it to you, that what my order says, word for word, my order says, as such, the court hereby issues a permanent injunction until such time that Mr. and Mrs. Olsiums complies with and receives the state DATCP rental license and the Burnett County rental permit and continues to do so annually as required, and until such a time that the above depicted nuisances can be abated. So there's two things here. I hear your argument about nuisances. You want the Court of Appeal to look and see, wow, Judge Mogan doesn't understand what nuisance law is, and that's fine. But then there's that other first part that the court clearly says, permanent injunction, meaning not one, not two, not three, zero. No free days, no none days, no, I'm going to give it to you for 30 days, but I'm only going to charge you for 1 day. But don't worry, it's going to be $30,000 for that 1 day. But I'm only renting you for 1 night. Clearly says permanent injunction until such time that you and Mrs. Olsiums, that you comply with and receive the state DATCP rental license. That you do that. And the Burnett County rental permit, and you continue to do so annually. So you stay compliant. The order does not give you authority in any way, shape, or form, to rent at all, even with the Burnett County ordinance of, having, or the state, which says 10 nights or less, or 10 days or less. Nothing about that. And the court's order clearly defined all of that. I had all of that information in my order. So if I was going to give you authority to say, all right, you can rent it for 10 days or less. I mean, really, you can rent it for 20 days as long as you give them 10 for free. That's totally fine, but charge them for the 20, but you only rent them for 10. I said nothing about any ability to rent at all. It's a permanent injunction, permanent until you do those two things, all right? Until you do those two things. You did not do any of those things. Instead, you rented it, you were found in contempt, you had far more days for the rental at the last contempt hearing. So the court found you in contempt, and this hearing, or this case, you're like, I'm gonna outwit the legislature. I'm gonna outwit the Burnett County Board. I'm gonna outwit Judge Mogan and Attorney Anderson. That's what you thought. You thought you're smarter than everyone else in the room. You are not smarter than anyone else in the room. I was number 2 out of 105 people in my law school graduating class, okay? I know how to analyze the law. You were trying to be sneaky and deceptive, and you were trying to get away with something that is clearly not legal or correct. You rented over the 10 days again. Again, whether it's 11 days, whether it's 13 days, whether it's 14 days, you admit on the stand and at the table it was 10 days. I rented 10 days, exactly what I said I could do in the ordinance. I did not do above. But I did give them 5 free days. Can't remember anything else, but I gave them 5 free days. So that's 15 days. 15 days you admit to. 15 days you admit to. I don't even have to go with any evidence or anything that's been filed or served by or received by the court from Mr. Anderson. You admit to 15 days. 10 you rented for money and 5 you gave for free. Even if I were Mr. Olsiums to take you and believe you, that is your understanding. And even if the court were to go, I don't think I wrote my order as clearly as I should, which I did though. Even if I took that and listened to your argument, you violated the ordinance. Free days count, Mr. Olsium. Free days are not free days, especially when you're charging $6,980.48 for 2 days. What fool's gonna pay like almost $3,500 a night? A fool would pay $3,500 a night. It's absurd. It's ridiculous. And I can't believe you think that a court would fall for it. The Court of Appeals will not fall for it. I'm telling you that. They're very smart. Probably smarter than I am. They do this all the time. They're not going to fall for your shenanigans. They're not going to. You're nodding your head up and down. I don't know what that means if you're saying yes or not, but that's where we are. You violated the order again. So I do find you in contempt for these violations. Further, beyond that, you didn't follow my August 29th, 2025 order. Very, 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 very clear. $2,500 for each, capitalized each violation, parentheses 2, totaling $5,000, plus a 45-day jail sentence for each, capitalize each, violation to be served consecutively. Serve 1, serve 2, for 90 days jail in parentheses. The jail sentence may be purged. You may get out of that completely. I don't have to do it. That's good. I don't want to go to jail. On the following conditions: full compliance with the October 4th, 2024 court injunctive order. One way that you can purge it, plus the second way, full payment of the court sanctions, fines, and fees within 60 days. Court calculated it. I did it twice. I did it 3 times actually. The deadline was October 27th, 2025. October 27th, 2025. Let's get to that. That was a Monday. You had until October 27th, 2025, Monday, to pay that, to purge your jail. You didn't do that. Moreover, even still, your motion that you filed to stay all orders pending appeal was filed on November 3rd, 2025, beyond the deadline that I gave you to purge. Beyond that, it's late. It doesn't count. You may want me to stay the other decisions, that maybe the other parts of it, I guess. I don't even know, because I'm going to tell you your motion, your petition here, it's hard to understand. Doesn't even make sense. And you're just spewing things that you think and you interpret as the law, or actually what you want the law to be and how you want it to be. So you can follow it and you can do what you want. So the motion to stay is denied. I don't find that you've met any of the factors that you need to meet. I don't think there's a high likelihood of success on the merits. I just went all over that. I don't think you're going to be irreparably harmed by if the court doesn't stay it, because it sounds like you're going to do what you want to do anyway, and you're going to try and do it and just hope you don't get caught. Harm to the other parties, harm to all of the other plaintiffs and all the other people here is higher than yours, because you continue to do these things. Not only, we're not just talking about the sewer. That went away. That was the only time I heard about it. Then I heard about the damage to the trees. I heard about the urinating in front of their camera. I heard about all of those other things in which the court found you nuisances, you violated, you did things that interfere with their ability to enjoy their property. The public interest here, I have to weigh the public interest. And here the best interest of the public is not to stay. It's to continue to have these specific parameters in place that you must follow, because it's been shown that you do not follow. You don't follow the law. You don't follow what the legislature says. You don't follow what the law enforcement says. You don't follow what the court says. You don't follow what anyone says but you. So I'm denying your motion to stay. And I'm finding you in contempt of the court's contempt order. I'm imposing those sanctions. You failed to pay $5,000 by October 27th, 2025. That means that the jail sentence stays 90 days in custody immediately. As to the other parts of the order, the court will again stay on that and we'll get it out. So you'll be remanded to custody for your 90-day sentence. You failed to purge. You did what you want.
Your Honor, can I purge right now?
No, you didn't have the money. You literally just said on the stand. Stop.
I have a credit card.
Stop. You literally said on the stand or on your table under oath, but I don't have the money. I can go back on a transcript. I can go back. You said those words.
I don't have it. I have it on a credit card though.
That's money. You could have paid it on a credit card by October 27th, 2025. But if you read my order clearly, words are clear, by October 27th, 2025, then the jail goes away. It's February 6th, 2026. Far beyond that. The court's enforcing it. You're remanded to custody immediately, 90 days. Thank you. We're adjourned. Sometime you have to start abiding by the law and orders of the court, Mr. Olsiams.
Can I purge, Your Honor? I have a lot of business and things that I wouldn't.
Well, what you can do is you can pay it and then you can write a letter to the court and then I'll consider it. But right now my order is very clear, very clear. The purge condition was very clear. So if you would like to pay it and then you would like the court to, it's called reconsideration, you sure can do a motion to do that.
Can I do that right now?
No, you have to go up to jail.
how would I make?
Go up to jail.
At the conclusion of the hearing, Judge Mogan ordered Mr. Elysiums to be remanded immediately into custody to serve a 90-day jail sentence. Here, Mr. Elysiums sought to purge his contempt and stay the judgment, but the judge denied his request because he had already missed the 60-day purge deadline, failed to pay the $5,000 in sanctions, and explicitly admitted on the record that he lacked the funds to satisfy the court's financial requirements. Under Wisconsin statutes, section 805.17(2), Judge Mogan sat as the sole finder of fact, giving her exclusive authority to evaluate witness demeanor, honesty, and credibility. Following Wisconsin statutes 906.07 and 908.01(4), bis days, which govern witness impeachment, prior inconsistent statements, and party admissions, a trier of fact is under no legal obligation to accept uncorroborated assertions. When Mr. Elysiums provided conflicting statements under oath, the court was fully empowered to reject his last-second pivot and hold him strictly to his prior sworn testimony on the transcript. The ruling relies on Wisconsin Department of Agriculture, Trade, and Consumer Protection rental license requirements, Burnett County Short-Term Rental Standards, Section 30-455, and Burnett County Parking Standards, Section 30-480, which mandate valid state licenses, local permits, and strict parking controls before any short-term rental operation can legally occur. And according to State versus Gudenschwag, a party seeking a stay pending appeal must satisfy a four-factor balancing test. 1. A strong showing of likelihood of success on appeal. 2. Irreparable harm to the movement. 3. No substantial harm to other interested parties. And 4. No harm to the public interest. With all that evidence in mind, Judge Mogan determined that Mr. Elysiums failed to meet the Gudenschwager criteria, lacked credibility, and demonstrated an ongoing pattern of non-compliance that suggested he would continue to circumvent court orders and local ordinances. With that, the judge denied the defendant's motion for a stay pending appeal and ordered the immediate execution of the contempt sanctions and commitment order. This hearing reminds us of the importance of following the court orders. During the hearing, Mr. Elysiums tried to circumvent the court orders by claiming he stayed under a local 10-day rental limit. Since the court issued its original permanent injunction on October 4, 2024, barring all rental activity until state and county permits were obtained, until the court's October 27, 2025 purge deadline passed without him paying his required sanctions, Mr. Elysiums repeatedly operated his property unlawfully. Mr. Anderson used court exhibits, rental receipts, and financial calculations showing at least 13 to 15 recorded rental nights to explicitly dismantle Mr. Elysiums' claims, proving his free days argument was merely a way to bypass local zoning and licensing laws. Judge Mogan, reviewing all the evidence, prior court orders, and the legal standards for a stay, systematically dismantled the defendant's excuses. With that, Mr. Elysiums' motion to stay was denied and was held in civil contempt, immediately remanded into police custody in open court to serve a 90-day jail sentence. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.